Hello everyone, I hope you all are fine. So yes, our today's topic is dying declaration under Indian Evidence Act. This topic is very important for law students as well as judicial aspirants. So let's start with the topic. Now, whenever any offense has been committed, there is always the two persons who knew that what actually happened. That is, first person is the accused who committed the offense, and second is the one who is the victim, like with whom the offense has been committed. So now, in order to prove their position and make one story to be true, they give some statement to the judge, but their story, one cannot rely on the statements which they made to support their stories, as it may be untrue. So generally the role of witness becomes crucial to determine the truth. Now there is a condition when the statement made by the person to be treated as true evidence in spite of the fact that he made the statement in his own favor and hardly any doubt behind the reason for that statement, and that condition is known as dying declaration. So dying declaration is a statement which is made by the person while he was dying and state the reason for his death. Now the statement given by the dying person can be circumstantial or tells the cause for his death. Hence the only statement given just before the death of a person is called dying declaration. The person who is conscious of compos mentis and knows that the death is about to happen can make a declaration and state the cause of his death, and that statement will be admissible and treated as evidence in the court. Now declaration made by the deceased person can be in oral, written or by conduct. The word dying declaration explains the word itself. Now why this topic is in the news? Now recently a special Central Bureau of Investigation, that is CBI court, awarded two policemen life sentences for the custodial death of a murder accused on the basis of dying declaration made by the victim prior to his death. CBI is the premier investigating police agency in India. It functions under the superintendence of the Department of Personnel, Ministry of Personnel, Pension and Public Grievances, which falls under the Prime Minister's office. Now there are some key points about this. First is Section 32 Clause 1 of Indian Evidence Act 1872 defines dying declaration as a statement, written or verbal, of relevant facts made by a person who is dead. It is the statement of a person who had died explaining the circumstances of his death. Now this doctrine is based on the maxim called nemo moriturus presumptuner mentri. That is, a man will not meet his maker with a lie on his mouth. Now the general rule under section 60 of the act is that all oral evidences must be direct. He heard it, saw it or preserved it. Now there are some rules regarding the admission of dying declaration. The grounds of admission under a dying declaration have been based on two broad rules. First is the victim being generally the only principal eyewitness of the crime. Second is the sense of impending death, which creates a sanction equal to the obligation of an oath in the court. Now, how the recording of dying declaration is done? Now, according to the law, anyone can record the dying declaration of the deceased as per law. However, a dying declaration recorded by a judicial or executive magistrate will add an additional strength to the prosecution case. A dying declaration may in several cases be the primary piece of the evidence to prove the genesis of occurrence. The only requirement of such a declaration to be held perfectly accountable in court is for the victim to volunteer the statement and be of conscious mind. Now the person who records the dying declaration must be satisfied that the victim is in a fit state of mind. Now there are some situations where court does not accept it as an evidence. Now these are, though a dying declaration is entitled to great weight, the accused has no power of cross-examination. This is the reason of the court that always insisted that the dying declaration can be of such a nature as to inspire full confidence of the court in its correctness. Now the courts are on guard to check if the statement of the deceased was a result of either tutoring, prompting, or a product of imagination. Now what is the need of corroboration? That is, corroboration means supporting evidence. Several judgments have noted that it is neither rule of law nor of prudence that dying declaration can be acted upon without corroboration. Now, if the court is satisfied that the dying declaration is true and voluntary, it can base conviction on it without corroboration. Now, where a dying declaration is suspicious, it should not be acted upon without corroborative evidence, because a dying declaration does not contain details to the occurrence. Now, it is not to be rejected equally merely because it is a brief statement. On that contrary, the shortness of the statement itself guarantees truth. Now, what is the validity of medical opinion? Now, normally the court, in order to satisfy whether the deceased was in a fit medical condition to make the dying declaration, can look up the medical opinion. But when the eyewitness has said that the deceased was in a fit condition and in conscious state to make his dying declaration, the medical opinion cannot prevail. Now, what are the types of dying declaration? There is no particular form to be employed in making the dying declaration. It can be oral, written, gestures and signs, thumb impression, incomplete, and can also be in form of question answer. So, however, there must be a distinct and definite assertion on the part of the person who produces the statement. Possibly the declaration should be in written form in the exact words stated by the person who made the statement. When a magistrate records the dying declaration, then it should be in question answer form, as the magistrate will opt the maximum information rightly, as in some cases dying declaration become the sole way to help in conviction of the accused. Now, what is the reason for admitting dying declaration in evidence? A dying declaration is admitted in evidence as there is truly based on the principle of nemo moritans pro istamur mentri. Man will not meet his maker with a lie in his mouth. Dying declaration does not require any corroboration as long as it creates confidence in the mind of the court and free from the form of tutoring. Now, in the case naming Yukaram versus State of Rajasthan, the court held that the dying declaration is admitted upon consideration is made in extremity when the maker of the statement is at his bed end. Every hope of the world is gone and every motive of falsehood is silenced and mind induced to speak only truth. Indian law recognizes the fact that a dying man seldom lies. Now, in a case naming State of MP versus Dharendra Kumar, in this case, the mother-in-law of the deceased was in a position to reach the upstairs within 5 to 6 minutes after hearing the cry of the deceased. According to the opinion of autopsy surgeon, the deceased was able to speak about 10 to 15 minutes. The Supreme Court did not agree with the view of the High Court that the deceased is not in a position to make the dying declaration, as it was reaffirmed by the autopsy report and circumstances of the case that the deceased was in a fit state of mind to talk when her mother-in-law reaches the place where the deceased was dying. Now, there is another case naming State of Orissa versus Parsuram Naik. In this, the husband was alleged that he poured petrol on the body of his wife and lit a fire, whereof extensive burns injuries were sustained by the deceased wife. It was held that by the oral dying declaration to her mother cannot be accepted because there was no certificate by a medical officer certifying that the deceased was medically fit to make a statement. Now, there are some statements made in different languages. Now, when two dying declaration was recorded in two different languages, as in one in Marathi and the other one is Hindi, then the dying declaration will be considered that one in which deceased were proficient in both the languages of the statement could be on the basis of conviction, as it was held in the case of Amar Singh Munna Singh Suryavanshi versus State of Maharashtra. Let me repeat this thing again. In the case of Amar Singh Munna Singh Suryavanshi versus State of Maharashtra, there are two dying declaration which was recorded in two different languages. One is in Marathi and the other one is in Hindi, and the deceased were proficient in both the languages. The statement could be on the basis of conviction as it was held in this case. Now there are some points which are to be remembered. First, a dying declaration made by the deceased can be recorded in any language. Second is, if the statement was recorded in another language than the one which magistrate recorded, then the precautions should be taken to explain each and every aspect of the phrase. Third is, the court cannot deny or discard the dying declaration only on the ground of language. So there is a case naming Biju Joseph versus State of Kerala. It was observed by the court that only ground that the statement of the deceased made was in her own language cannot reduce its value of dying declaration. It was given by the High Court of Kerala. Presume that the statement made by the deceased when he was dying recorded in his language in which he has command or fluent does not vitiate its value, and court cannot deny it or reject it on the basis. Judicial magistrate entrusted with the duty to convert statement in court language, and such translation process would not affect the credibility of that dying declaration. Now what if there are multiple dying declarations? Supreme Court of India, in concern to multiple dying declaration, it can be considered upon without corroboration if there is no breakdown of fact in all the dying declaration. If the dying declaration are similar to each other and state correctly the cause of death and there is no contradiction between the statement, it can be admissible. But if the dying declaration is different from each other and there is a contradiction between them, then the court will cross-examine the facts of the case or can examine the statements of other witnesses to determine the truth and sanctity of statement regarding the case. The statement of the deceased should match the facts and circumstances of the case. It is very important to understand the character of multiple dying declaration. Now there are some points which has to be considered in multiple dying declaration, that there should be regularity in all the dying declaration. If the dying declaration does not match or say overlap, then the court will examine the facts of the case with the dying declaration or examine the witness. Now there is a case naming Kushal Rao versus State of Bombay. In this case, the court set the important rules for dying declaration and what is the right process or manner to record it. In this case, if the dying statement made by the deceased that it should be recorded in the form of question answer form shall be supported by the doctor that the deceased was in good mental state, can be recorded by the person who is legally entitled to record it. If there are multiple dying declarations, then it should be consistent so that the court can rely on it. Now the Supreme Court has held that multiple dying declaration can be reliable when it is made without corroboration if consistency is maintained throughout the statement. Otherwise, the court would have to cross-examine the statement or other witnesses to determine the truth in a criminal trial. I hope you understand this topic and it is helpful for you. Thank you.